Welcome everyone to this new episode of the PrivacyRules Privacyespresso series where we delve into the latest privacy, data protection, and technologies in general from all over the world. Today with me, I have Trevor Fenton, partner from the law firm Shakespeare Martineau, that is the exclusive member of the PrivacyRules Alliance for the UK. Trevor is an expert, of course, in privacy and data protection. And I've been inviting him today with us to discuss about very recent topic. It's about 1 week ago. It is the complaint raised by Open Rights Group against Meta, which follow the flows of a series of facts that we have been seeing also in the EU with the NOYB group that was acting against Meta as well. So we're going to delve a bit more into this case and some parts in relation to it. But first of all, Trevor, thanks a lot for being with us today. It's a pleasure to have you here.
No, thanks for having me.
Okay, first of all, Trevor, can I ask you to provide us just with a little overview on what we are talking about in this case, specifically for the UK?
Yeah, I think it's probably the same as it is for the EU. The essence of the complaint, as I understand, is that Meta had decided to start using personal data. Obviously, it's got masses of personal data in its database going back over the last almost 20 years since Facebook was launched publicly, but they want to use that data to train their AI models. And of course, if they're going to do that, they need, like any personal data controller, they need to explain to people what they're doing through their privacy notice, which, as I understand, if you take that privacy notice down from their website and copy and paste it into a document, it's something like 127 pages long. So that in itself is an issue we'll probably talk about. But the concern, I suppose, was using people's personal data to train AI models is in itself going to be difficult to justify using the legitimate interest, the lawful basis that Meta was planning to use. And I suppose Meta has since backed off and said, well, we're not going to start that, or I'm not sure if they said they're not going to do it at all, or maybe they're not going to start it quite yet. But in the meantime, they've updated their privacy notice to say that they're going to do this. They're going to rely on legitimate interests as their lawful basis. And since they've decided, since they've sort of stepped back from doing this kind of processing, they haven't actually updated the privacy notice. So it still says that they're going to use this data to improve their AI technology and to train their models.
Thank you for this introduction, Trevor. That raises a lot of questions, but one of the key ones also related to the UK version of GDPR that is very similar but not exactly the same as we know and you teach us. The first question I have for you is related to data subject. Can data subject somehow object to the processing of something that is not happening yet in particular? Or maybe this is one of the reasons why the authorities have been so reactive, and groups like the Open Rights Group has been so reactive in preventing this from happening.
Well, yeah, I think the complaint talks about Article 58, about an investigation under Article 58, and then a prohibition, asking for the UK's Information Commissioner to prohibit this kind of processing under Article 58, sub 2, I believe it is. And so in that sense, yeah, I think there is the possibility of a regulator, in this case the ICO, sort of proactively prohibiting a kind of processing if that processing doesn't pass a DPIA, for example. And it's pretty clear that a DPIA is going to be necessary for this kind of processing. The question is, what do they do in response to that DPIA? Do they identify high risks to data subjects? And have they, at that point, then brought the ICO in? If they haven't done all of that, you wouldn't think off the top of your head, you wouldn't think you can complain about processing that isn't happening. However, I think there is every ability under Article 58 to look forward and to say, hey, wait a second, we know what your plans are. Let's talk about that. And no, actually, you're not going to do that kind of processing. So as I understand, that's one of the main thrusts of this complaint, and the request from the complainant is to put a stop to this processing before it even starts.
Perfect. So it's also a way, for authorities and groups to, as we were saying, protect personal data. In this regard, looking on the side of the company, so Meta, you said before that you went through, the privacy notice. My question for you is there anything new there, or they just did something like introducing the AI term into the notice, and is this changing anything in relation to that?
Well, that's a good question. Does it change anything to tell somebody I'm going to take your personal data and use it to train my AI models? Because if you say that, let's remember what the whole purpose of a privacy notice is. It's to notify people, to explain to them what you're doing with their data, with personal data about them. So if you tell somebody a very simple sentence like that, we'll use your personal data about you to train our AI models, have you actually told them anything useful? Are they any, do they have any better understanding before you wrote that sentence what it is that you're doing, what the potential consequences are for them? Because our whole, under the GDPR, both the EU and the UK versions, which are for these purposes essentially identical, and under practically any privacy laws out there that meet the adequacy test, the EC's adequacy test, they all require the same kinds of things. They might come at it with different language, but essentially you have to tell people what you're doing. You have to explain it to them in terms they're going to understand, so they can. And if they don't understand, if you haven't explained it in a way that they can grasp the consequences or potential consequences of what you're doing, then you might as well not have written the notice at all. That's true if you use very, very short and vague language, such as we're going to use data about you to train our AI. But it also applies if you go too far the other direction, in my view. 127 pages of anything is what I would call a privacy notice by dumper truck. I mean, it's just so much information. Nobody's going to read it. Nobody's going to read it. And if your average person, if they did read it, it's still, you're left with the question, could they do they have a reasonable chance of understanding what it is that you're doing with data about them? And if the answer is no, then I don't think you've met the transparency requirements anyway.
That's very interesting, Trevor. Thanks a lot for providing us with this overview on document, in particular the notice and the issues related to that. And definitely, one of the key points, as you are rightly saying, is that even too long notice, even if they explain every single detail, they are not really something understandable, meaning that they are something very difficult to deal with. And in this regard, in your view, how do you see the next steps in this regard? Because we know that Meta now stopped, not just in the UK, but also in the EU, which might be the solution. Because one of the key problems here is also that, and this is very much related to the privacy notice, is also that Meta was using as a legal basis the legitimate interest, but the authorities in the EU, and I suspect also in the UK, are pushing more for a consent type of request, where the privacy notice is even more essential. Which can be the approach in this regard? What do you expect?
I don't know, and because I think the idea of using consent, especially the way it's conceived of under the GDPR, right? And by the way, I don't think consent under the GDPR is markedly different than what it was under the common law anyway, right? It needs to be fully informed. It needs to be specific to all these concepts really come from existing legal systems anyway. It's just that in this case, I think with the GDPR, the authorities have had to say, no, we really meant it. We mean that you have to, it has to be informed consent. People have to know what you're talking about. So if they don't understand what you're talking about when you write your privacy notice for a legitimate interest-based processing, how is it going to be any better if you switch your lawful basis to consent? Arguably that, that requirement for fully informing the data subject, that bar is arguably higher with consent as the lawful basis than it is with legitimate interest. Arguably, maybe it's the same bar. And so, yeah, you're faced with that paradox where I think, sometimes less is more, sometimes more information is more. And it's, I don't think there's a bright line between when when you've got a privacy notice that does the job and when it doesn't. It is a bit of an art. What underlies all of this, though, and I think a lot of controllers forget, or maybe don't want to address a problem they have, is that if the notice is too complex for people to understand, it's often not the notice that's the problem. It's the underlying business model and the underlying use of data. That's what's complex. And if the way that your business or your organization is using personal data about people, if those methods are so complex that your data subject doesn't have a real chance of understanding what you're doing, then maybe it's the processing that you're doing that's the problem and not the notice that you've written about the processing. There's really no answer to that. I mean, if you take what I've just said to its logical conclusion, you could end up saying, well, then AI should be illegal because nobody, your data subject has no real hope of understanding what you're doing. I don't think anyone sensible is arguing that, but I also think at the same time, there is no obvious solution to that paradox, right? When the data use gets that complicated, how do you keep people informed, and how do you make sure that remains fair? And if we're basing everything on the approach we see in the GDPR, which again, I don't think is GDPR specific. I think this is a common approach around the world. The idea is if you inform people, and if the underlying data use is reasonable at some level, however you measure reasonableness, if you have both of those things, then it should be fair. Well, how can you, if the use is really that complicated and you can't explain it to them, then that does raise the question, is it possible for this kind of processing ever to be fair? I don't know how to resolve that.
That's a big question, and of course, a complex answer. So thanks a lot for trying and for sharing your thoughts with us. That opens up, to another point that is also the one of, doing privacy by design with something like AI that is, so challenging, so new, that is always difficult to somehow, prevent. You never really know sometimes what you are creating in some ways, or how the data are going to be used. So it's very much difficult on the private company side to even, using or having a design ready before launching something. And this is one of the big problems and clashes that we are seeing whenever there is AI. Of course, there is a need for a lot of attention, probably more in some cases of the one we could witness. But of course, there is not a proper right answer. I mean, it's always about balances, as you were saying, and fine tuning with authorities and open a dialogue, which seems to be what we are witnessing. So we are looking forward to hear more about what's going to happen in the future. Thanks a lot for now for giving us this update, Trevor, and being with us. It's been really, really interesting listening from you. And I would also like to thank our listeners for being with us. This is the end of this episode, so thanks a lot again for being with us, Trevor.
Cheers.